There's one constant. I'm still the chief. This time we're on record in Stanley Consultants versus Integrated Financial et al. We have a fairly complex case here. Arguing on behalf of the appellant is Thomas Dvorak. Stanley Consultants, on behalf of the respondent, Rebecca Rainey, will argue for Integrated Financial Associates and Geneva Equities and the Idaho Golf Partners. Mark Perizone will argue on behalf of the intervener, Idaho Golf Partners, Inc. David Crook will argue on behalf of Hap Taylor & Sons, Inc. Justices Eisman, Warren Jones, and Horton are recused. Senior Justices Schroeder, Kidwell, and Trout will participate fully in this appeal. Any preliminary matters that you'd like to put on the record?
Yes, may it please the court, Tom Dvorak appearing on behalf of appellant Stanley Consultants, Your Honor. As a preliminary matter, there's sort of a distinction between the cross appeal here and the direct appeal. The first appeal involving primarily Stanley and IFA, whereas the cross appeal involved all the other parties. So the parties between themselves have determined to allocate the first half hour to the initial appeal and the second half hour to the cross appeal if that meets the court's satisfaction.
Agreeable? And you have then divided your time?
Yes, sir.
Very good. That's fine with us. Can the clerk make sense of that? I know everybody worked real hard to come up with a workable solution. I thank you for that regard. May proceed, sir.
Thank you, Your Honor. This case is about the plain meaning of Idaho Code Section 45-506. Namely, what does that section provide as to when the lien for professional services of an engineer, like Stanley, become effective? Stanley's position is the plain, obvious, and rational meaning of that statute creates the result that the lien becomes effective when the engineer begins performing the professional services that are the subject of the contract, regardless of whether those services are physically performed on site. Now, in the interest of time, we have a rather complicated and long history involving parties. In fact, I think at one point I counted a caption in this lawsuit that amounted to 7 pages of just listing the parties. You sort of have the last folks standing before you today as we go on for that. But in the interest of time, I'll sort of compress the factual and procedural background here a little bit. Stanley did work related to a clubhouse on a common area within a residential and golf subdivision. And this case really is here on stipulated facts. The case represents a legal question of statutory interpretation. Basically, on June 18th, 2007, Stanley signed with the owner of that subdivision, the developer at that time, professional services agreement with L222-2 Idaho Summerwind LLC, and that was to provide engineering services on Summerwind at Orchard Hills subdivision. Those services, by definition, in that professional services agreement in the record, including things like a topographical map sufficient to design the golf course building, a club building, and to design parking lot and drain facilities, included a grading and drainage map. It also included a design for a potable water line and a gravity flow sanitary sewer system. But, and most critical to the appeal today, it also included and defined administrative services. They were described as, quote, initiating the project, including setting up project files, preparing budgets and schedules, something that's obviously necessary to get everything moving in the right direction. Now, the parties have stipulated to the relative priority dates. The parties have stipulated in this case, and the judge entered the judgment based upon this, to the effect that Stanley commenced off-site work on the property at issue pursuant to his professional services agreement on June 26, 2007. That's the date that an entry shows for some of these administrative services being done by my client off-site. Shortly thereafter, on July 13, 2007, IFA came along, loaned some money on the site, and put a deed of trust on the property, which was recorded June 13, 2007. Thereafter, the first physical work on site by my client. Now, they had done work already in the form of these administrative services off-site. The first physical work on site was July 19, 2007. There's no dispute about the facts here. Again, this case is before the court on purely a matter of statutory interpretation. In fact, the final judgment that was entered in this case on April 23rd ruled, and this is what Stanley appealed, but the final judgment contains language to this effect. The priority date of defendant Stanley Consultants, Inc.'s lien at issue in this lawsuit for purposes of applying Idaho Code Section 45-506 is July 19th. The date actual physical work was actually conducted within the boundaries of the legal description of the property at issue in this lawsuit, and not the earlier date that Stanley commenced to furnish professional services under its contract for the project at issue. Now, the heart of this case is what's meant by certain language within 45-506, specifically language talking about commenced to be furnished. I'll forego with reading the statute, but basically the 45-506 uses the commenced to be furnished language several times and talks about the lien attaching when professional services were commenced to be furnished. The plain meaning, we believe, of commenced to be furnished is it means when the point Stanley started to perform professional services called for under the contract, which would be that June 26, 2007 date. And again, I want to refer this court, because I realized this just before I got to the argument, there's a recent interpretation this court actually did, or some members of this court, in a case called Farmers National Bank versus Green River Dairy, 155 Idaho 853, 318 P3D 622. It's a 2014 case. There the issue was about an ag lien statute, and whether the lien that was defined in an agricultural product actually extended to the livestock which had consumed that product. Sort of a funny setup there. But in that case, the statute at issue had two sentences. The first sentence talked about the lien being an agricultural product, and the second sentence could be inferred that that it was used in feeding livestock. But there was a separate section that actually defined agricultural product not to include livestock. And interpreting that case, and I think this is exactly the situation that's going on here, the court said that ambiguity in a statute exists when the meaning is so doubtful or obscure that reasonable minds might be uncertain or disagree as to its meaning. However, ambiguity is not established merely because different possible interpretations are presented to a court. If this were the case, then all statutes that are the subject of litigation could be considered ambiguous. And here's the important part. A statute is not ambiguous merely because an astute mind can devise more than one interpretation of it. Now, as we go through the statutory scheme today, is the statute here a little clunky? Perhaps, but I think the meaning shines through, and it's a single, unambiguous, plain meaning of the statute. In fact, in that farmer's case, it was noted that the district court had focused too tightly on the word uses in that main statute that contained those two sentences and had disregarded the statutory definition otherwise. And I'd submit that same thing's going on here. The language...
Mr. Dvorak,
yes,
is it your view that the lien can be perfected even if plans are not furnished?
Well, I believe that furnishing plans, Your Honor, I believe that the use of the word furnishing implies that they can just be drawn and they're required to be produced pursuant to contract, Your Honor. I believe that it's the point at which they commence performance of the contract in those plans.
I understand that. I'm trying to figure out what activities are required before the lien can actually be filed. So does there have to be some kind of plan or something that ultimately is created in order for the person doing the work to be able to file a lien?
Your Honor, it is our position that the language of the whole statutory chapter, especially the language of 501, contemplates that engineers have a broad lien for any kind of service that they furnish or render whatsoever from the commencement of that service. There's language within that statute, especially 501, that talks about services rendered in connection with any land development whatsoever. And the statute itself, especially the language of 501, ties it back to the professional services contract. I quote from 501, every professional engineer or licensed surveyor under contract who prepares or furnishes designs, plans, plats, maps, specifications, drawings, surveys, estimates of cost, on-site observation or supervision, or who renders any other professional service whatsoever for which he is legally authorized to perform in connection with any land or building development or improvement or to establish boundaries, has a lien upon the same for the work or labor done or professional services or materials furnished. We'd note a couple things in answer to the court's question on that. First, this list is not exclusive. It ends by saying any professional services whatsoever in connection with any land. There's no other analogous right of any other lien claimant which just says anything done in connection with this.
So if Stanley had only done the initial hour and a half prior to IFA's lien, that would be sufficient for them then to have filed their lien?
They've begun to render or furnish services at that point in the sense of the plain meaning of the statute, Your Honor. It's under their professional services agreement.
So the answer is yes?
The answer is directly yes, Your Honor.
And I assume that there doesn't, in your view, have to be any actual building or construction or anything else. If the whole thing fell through before anybody ever moved any dirt, your view still is that because some type of engineering services were commenced, that the lien could be filed.
And I believe that's the case, one, because the statute doesn't impose, first, for what I said in terms of the statute being as broad as possible, any services under a professional services agreement in connection with land whatsoever. Two, there's nothing in the statute that imposes an on-site requirement in contrast to that. And three, if you think about the types of things that engineers typically do, these plats, designs, anything else that they do, even if those weren't actually used to build something on the property, if that property is sold and a buyer is buying that property, those are the kind of things that buyer in his due diligence is going to demand, because those plans, even though done completely off-site, lend value to the property just by their existence. They are unique to that property and they lend value for it. I don't think we need to get there as it's the plain meaning of the statute is so clear. But if you have to look behind the plain meaning of the statute, there's a good reason why the statute is written in such broad terms, Your Honor. And I see that my time is short, so at this point I would yield to the respondent. Thank you. Unless there are further questions.
No further questions on that. Ms. Rainey?
Thank you. Chief Justice Burdick, and may it please the court. Rebecca Rainey on behalf of Integrated Financial Associates. The issue that's presented by this particular appeal is not so much an issue of what types of services the engineers provide that are lienable, but when the priority date for those services become lienable. What Stanley Consultants is arguing is that engineers, by virtue of the type of work they are doing, are entitled to some sort of super priority lien rights that gives them priority for work that is not visible on site, that cannot be seen by a subsequent buyer or by a subsequent lender, that nobody might know about. Say, for example, 1.5 hours of administrative services.
But isn't that what the legislature, he's not arguing that he believes that, he just says the legislature gave this to us. So haven't they taken that title issue into consideration?
I don't believe that they have in this case, because if you look at how the language of the statute is written, it's the phrase where professional services is addressed is where it refers to material men in that same phrase. And it says where materials or professional services are commenced to be furnished. So the argument presented by Integrated Financial Associates is that the commenced to be furnished language, because it's used exactly the same with respect to material men as it is with respect to those providing professional services, needs to be afforded the identical interpretation. Now, the critical part to that is this court, in the case of Beal Pipe, did indeed interpret that commenced to be furnished language with respect to material men. And in Beal Pipe, they had started preparing the pipe for shipment off-site and were trying to obtain that as the priority date for their lien. And this court said, no, it is not until the materials are delivered on-site. That is
so in order to have a lien, as an engineer, I have to go out and put my plans on the site? There
needs to be some sort of delivery.
Well, isn't that kind of nonsensical?
Your Honor, I don't believe that it is nonsensical. The sense of delivery with respect to engineering services clearly is different than what it would be for materials. Professional services are delivered in a different way than materials are delivered, but you can still create something that looks like the delivery of professional services. If you look at the case of Chief Schwindeman, it makes it clear, and I'll read directly from the case. The right of the lien is based on the theory that the claimant has, either by his labor or by the materials furnished and used, contributed to the construction or improvement of the property against which the lien is asserted. It goes on to say, hence, where the labor is not used or the materials are not incorporated into the building, structure, or improvement, no lien on the land or building results. This gets back, Justice Trout, to some of the questions that you were posing. What happens if the project goes bust and nothing is ever to come of the professional services that were rendered? If they just sit in the engineer's closet, the plat is never recorded, the maps are never done. In that case, it would be IFA's argument that no lien rights do exist because the land has not indeed been improved. So I think the test that this court could look to create for that is the delivery of a professional service is the time at which there's some improvement, some tangible improvement that can be pointed to, whether or not the plat's recorded, something of that nature. Here,
So engineers are professionals, lawyers are professionals. The analogy would be you would put 40 hours into a brief and you wouldn't get paid until you delivered the brief to the court for your 40 hours. Is that what you're saying? I mean, the engineer's documents, et cetera, are much the same as the lawyer's.
the distinction with that analogy, Your Honor, is
Obviously, we don't get a lien, but
well,
the work goes into the product before it's ever delivered.
and that's precisely the case. And there's always going to be contract rights that exist between the party ordering the services, the lawyer and the client, the engineer and the client. The fact here is it's a proceeding en rem. The party to the entity or the thing against which the lien is asserted is not the party that's contracted for those services. It's the property that's being improved by those services. If the property has never been improved by those services, the property should not be responsible for payment of those services. And I think, Your Honor, that's the critical distinction between, doing the work and getting paid for it, or being to extract payment from that work in a proceeding en rem, such as exists with these mechanics liens.
So I take it that if the engineer drew up some plans and I realize that the contract here called for him to go out to the site, but say the engineer draws all this stuff up and it's handed over to the contractor and he uses it, completes the building and all that stuff, but the engineer never goes out to the site, he can't get a lien.
No, Your Honor, that's not what we're arguing. The argument would be, as soon as the engineer's work in some way is incorporated into the improvement of the value of the property. As we discussed earlier.
So that would be dependent on a materialman or a contractor going out and doing something to the land.
Or perhaps it getting recorded in the land records as though there's been a plat filed, something like that, some sort of visible, tangible improvement to the land that is the result of that work. Not just some abstract work sitting in the closet of an engineer somewhere that never does improve the value of the land in any way.
But of course, that's not the facts in this case, is it?
Well,
This stuff didn't lay in a closet. There was a whole bunch of work that went on as a result of this work.
Yes, so the question is, when do they get the priority date? And our argument is they should get the priority date for that work the first time that their work became incorporated into improving the value of the land.
In this case, that would be when?
That would be at a minimum July 19th when they started, when they were on site starting to do on-site work. There's no evidence in the record that there was any sort of incorporation of their efforts into improving the value of the land at any time. I would take a slight issue with the characterization that the district court made in her order that they actually needed to be on site. We're not arguing for that strict of an interpretation. It's just that there needs to be some form of delivery. And I think it is open for this court to determine what does commenced to be furnished look like with respect to professionals as opposed to what it looks like with respect to materialmen. This court has already made it clear that with respect to materialmen, it means on-site delivery because materials cannot be incorporated into the land until they are delivered on-site.
Ms. Rainey, Let me follow up before you leave it. Your analogy on filing the plat.
Yes.
So you would suggest that until mechanically somebody walks in and files the plat, that there should be no priority?
I would suggest that that is one way to define
That is
the
one
delivery.
way.
Yes.
So you would acknowledge that before that plat is filed, there's an awful lot of work that goes in to what they're going to file.
I would agree with that, Your Honor, yes.
So that should not count on the priority date.
That's correct, Your Honor. It is lienable work, but it is not work that counts on the priority date. A similar analogy exists with the individuals that are preparing pipe for shipment. All of the cost of what it takes to get that pipe ready to be shipped across the country is indeed incorporated into the cost of the pipe and the cost of the delivery of the pipe, just like the engineer's services would be incorporated into that pre-delivery work. But just as the pipe materialman can't get a priority date until it's actually been delivered, the same should hold true for the engineers.
So if the person filing the plat is hit by a truck and it doesn't get filed?
Your Honor, the question would be...
I mean, I'm obviously exaggerating to make a point. So the plat doesn't get filed for 3 days.
The question I would have is, was the plans that were contained in that plant, were they used? Did they start breaking ground pursuant to those plans? Because I think if someone had broken ground...
You're adding a new variable there.
Well...
You say that they have to physically do something on the land?
No, Your Honor. With all due respect, what I said in response to your question about filing the plat, I said that is one way to measure delivery. It's been discussed previously that an additional way to measure delivery that has been discussed is there's been some dirt moved. There's been some incorporation of the type of work that the engineers were doing into improvement of the property. So there's a few different ways to look at how the engineer's work has been delivered. And the test is there any improvement that we can look at? Filing of the plat, movement of dirt pursuant to the plans that the engineers have created. If we have surveyors, are they out there actually placing stakes and doing measurements? Those types of actual ascertainable improvement of the property.
Can we back up just a bit, and can you point to me specific language within 501 or 506 that says that a reasonable person reading it up front would just say, oh, yeah, something actually has to be done?
Your Honor, where we get that from is the fact that it's got the same language with materials or professional services commenced to be furnished. The legislature amended the statute in 1971 to add the professional services language. That was after the Beal Pipe decision had been rendered. When the legislature amends a statute following a decision of this court, it is presumed that the legislature knew and understood what the court had decided and was in agreement with what the court had decided. And indeed, what's that?
In agreement? That rarely happens. Usually it's as a result of that dumb court. We got to change this.
But usually they make it clear. And in this case, they didn't make it clear that was the change. And this court noted in Ultrawall that very thing. In the case of Ultrawall at 135 Idaho 832 at 835, this court said, moreover, the addition of the term or professional services to Idaho Code 45605 in 1971 suggests that the legislature was content with the court's interpretation and application of that statute. The court must assume that when the statute was amended, the legislature had full knowledge of the existing judicial decisions and case law of the state. Now, that was a slightly different issue, but the same rationale.
But again, Ultrawall was a sheetrocker who was depending on the engineer's commencement of work, not his own. That was the issue in Ultrawall.
Right.
And as a result, it wasn't the engineer who was asserting the lien. It was someone who was trying to piggyback onto the engineer, which obviously each stands alone.
Right.
What do you have to say to that?
Well, I'm citing Ultrawall here. Ultrawall clearly is dealing with a different priority scheme and the attempt in that case of the sheetrock lien claimant to disrupt the very, very long-standing priority scheme. I think the important point in Ultrawall is to note that this court's recognition that the legislature is paying attention to what the court is doing, and when it added that professional services language, there was very long-standing case law in the form of Beal Pipe that said there must be some sort of delivery. If something different had been required with respect to engineers or intended with respect to engineers, you would expect to see it expressly referenced, not just plugging those professional services.
Why would we expressly reference it when, in fact, we're talking about a sheetrocker as opposed to an engineer? I mean, appellate decisions are narrowly written and interpreted only as concerns the question that has to be answered. In Ultrawall, it's a mechanic. It's a sheetrocker.
No, Your Honor, I was suggesting that the legislature should have expressly referenced that they wanted engineers to be treated differently than materialmen.
Okay, well, in that regard, let me ask you, when the legislature amended the statute in 1971, they said something about engineers that they hadn't said about materialmen. And they said a professional engineer or licensed surveyor under contract. Can you tell me what under contract means?
In that context, Your Honor, I would just, I don't know specifically what the legislature meant. I would presume that it just means the plain language. There was a contract in place.
And I take it that that maybe the reason for that language is that they wanted to identify the services to a particular piece of property.
Yes, and Your Honor, I think that the way that 501, which is where that language is contained, 501 talks about what types of things are lienable. And that's a different question from when those lien rights attach. What is the priority date, which is addressed in 506? And I think the commenced to be furnished language and the way the legislature used that identically with respect to materialmen and professional services necessarily imposes some sort of on-site delivery and or improvement to the land based on this court's prior interpretations of Beal Pipe. I see that I'm out of time. I'll stand for any additional questions you might have. Otherwise, I'll excuse myself.
Well, I guess I do. I just want to clarify that you acknowledge that there would be circumstances that a surveyor, engineer, or architect would not be delivering anything in the same sense that a materialman would, delivering a product that subsequently gets incorporated into a building. An engineer may not do that at all. You gave the example of recording a plat. Well, that's not any on-site activity at all. So it seems to me that there is a difference in terms of furnishing materials or furnishing a plan, a design, an estimate, whatever it is that may not, I think it breaks down because whatever it is that the professional is providing isn't going to go right out there and suddenly get incorporated into an actual building, which, as I say, a materialman would. So I'm not seeing that those should be treated the same for the purposes of commenced to be furnished.
And Your Honor, the only comment that I would have with respect to that is the intent of the mechanics lien statute is based on the improvement to the value of the land. So without some improvement to the value of the land, I don't believe a lien right should exist. That's why the engineer can recover against the land. And if there's not some sort of tangible improvement to the value of the land, I do not believe that those professionals should indeed have
But the
a lien right.
legislature could change that at any minute.
They could change that at any minute, Your Honor. Yes.
And I suppose they will argue that, in fact, they did in 1971?
I will leave that to them.
Okay.
Thank you, Your
Madam.
Honor.
Sir, how much time does he have? 5 minutes.
Thank you, Your Honor. First thing I'd say is, and is notably glaringly absent, where is the provision that says services by an engineer must be rendered on site? Again, we go back to the plain meaning of this, and in fact, I'd like to direct the court's attention to a statute which we didn't cite in our briefing, but it's still found within the same chapter, much of the same situation as the farmer's case. 45505, land subject to lien. They amended this statute too in 1971 when they were amending both 501 and 506. When they amended 505 in 1971, they added in that in connection with for professional engineers, and to me this is game, set, and match. The land upon which or in connection with any professional services are performed, or, this was the existing statute, any building, improvement, or structure is constructed together with a convenient space about the same, or so much as may be required for the convenient use and occupation thereof to be determined by the court rendering judgment, is also subject to the lien. If at the commencement of the furnishing of professional services or other work, and then they go on and talk about the supplying in there, but it's that in connection with. That is something completely new to the statute and foreign from what traditionally had been done for mechanics and materialmen. In fact, some of the language, if you look at 501 at the very beginning, talks about a materialman who furnishes materials on site. Now, that's not the interpretation that, that was used in the Beal Pipe case. The Beal Pipe case cited back to the Pacific States case, then cited to a Washington case, and it's not very well reasoned other than to say there's a general rule out there. So I don't think it's a very good plain meaning interpretation, one, about Beal Pipe. Two, it was said at least 7 times that Beal Pipe is a case of this court. It is not a case of this court. It is a case of, not to denigrate the Court of Appeals, it's a case of the Court of Appeals, not this court. And it wasn't about professional engineers. Just because in 71, when the legislature decided to graft on the language regarding professional engineers into the existing statute and try to do as little violence as possible to the language of the existing statute in doing that, they made the commence to be furnished language do double duty and apply to...
You know, how do we, as Justice Trout brought up, how do we protect the people that are primarily financing these projects? How do they come into a project and make sure that they are in first position, which that is very important to society in general, that the main financiers get a good position?
Your Honor, that's why we have title insurance. That's why we have investigations done. That's why affidavits, for instance, are solicited by developers as part of ordinary due diligence of banks, claiming that I have not done anything. Here are the only engineers who worked on the projects. So that if those affidavits turn out to be false, it becomes fraud, it becomes non-dischargeable in bankruptcy. There are other procedures for them. If they want to find protection within the lien rights that are to protect persons who bring value to the property, materialmen, engineers, and others, they need to find that within that chapter. It's not there. The plain meaning of the chapter is not for them. They have mechanisms to do that. They can also go lobby the legislature, as the court pointed out. But it's just not there, and this court's job is to apply the plain meaning of the statute. And again, the distinction, and it was pointed out in some of the discussion here, would lead to some absurd results. If this court were to rule as IFA is requesting, does an engineer now suddenly say, well, I'm making a plan, but part of that plan better be for me to put one single stake in on site right away? Now I have my priority at the very beginning. That's an absurd distinction. The court should make clear, bright line rules. There's plenty of law as to when a contract begins to be performed. That's easily understood. It's a clear, bright line rule. Their whole analogy to materialmen, one, is only based on the Beal Pipe case. It breaks down.
So you've just indicated there's a lot of law as to when a contract is commenced.
Is performed.
So you and I'm an engineer, you're the developer, we meet it for lunch, and I say, yeah, for $20,000, I'll do the following for you, and you say, I'll pay you $20,000. Okay, we have a contract. Is that when this lien starts?
The lien starts when I begin to perform my end of the contract as the engineer. When I begin rendering what I've agreed to render under the contract. And that's exactly what the plain language of the statute says, Your Honor. Professional services agreement. Any service whatsoever in connection with, again, land development, or it doesn't, everything else talks about a building or land. That's the only portion of the statute that was put in 1971 that says anything in connection with the land development. They're talking about the abstract things that engineers do that add value that don't necessarily get reflected on the property. And there's nothing in there that says the priority date should be separate or come later from the day that services start under that professional services agreement. In conclusion, Your Honor, Stanley Consultants asks on behalf of professional engineers in Idaho that you reverse the district judge's decision and clarify that engineers enjoy lien priority from when they first begin rendering any professional services under the contract in question with a building or land development. regardless of the location of where those services are rendered. Such a ruling recognizes not only the plain, obvious, and rational meaning of Chapter 5, Title 45, but also ensures that the real value of an engineer's off-site work to a project, value in the form of plats, designs, specifications, estimates of costs, or other services not directly incorporated in that physical property, but indeed reflecting in the increased value of the property. Something
We get
anyone
it.
doing.
Your time is up.
Thank
sir.
you, Your Honor.
Thank you very much. As concerns the cross appeal, Ms. Rainey?
Thank you, Your Honor. Chief Justice Burdick, and may it please the court. With respect to this cross appeal, there are a lot of different things going on. So in an effort to try to simplify them for you, I've created some visuals that I'm going to use to walk through the factual background. This cross appeal involves the asphalt paving on the project. There were two types of asphalt paving at issue.
Were these exhibits used in the trial or in the trial court?
Yes, and they do appear in the record. We've simplified them a bit just to take out some of the messiness of the engineering thing so that it's clearer that you can see what's going on. I'm going to start with phase 2 of the project because that was the first construction of the roadways that was done. Here you see in this phase 2 mock-up, the green road was the first part of the project that Knife River paid. That portion of the project was paved in November of 2006 and it was paid in full. What you see in yellow, that's the golf course portion of the project. It's highlighted in yellow. You'll notice on this phase 2 mock-up, there are no indications of cart paths. That's because no cart paths whatsoever were constructed by Knife River on phase 2 of the project. Phase 1 of the project was done second. Here you see the red roads indicated. These were not paid. There's approximately $166,000 that was left outstanding for the paving of the phase 1 roadways at the time Knife River filed its lien. The last date of work that Knife River did on these roadways, and I'm going to clarify that a little bit. The roadways were substantially completed. I think that's the proper phrase to use here. On April 27th of 2007. On July 13th of 2007, my client filed its deeds of trust as the lender on the property. I believe they aggregated $9.5 million.
Ms. Rainey, I'm sorry to interrupt. The phase 2, the green road, you said that was paid for?
That was paid for, Your Honor.
And is that part of the 6,020 ton that was stated in the proposal?
Yes, it is, Your Honor.
From Masco at that point in time?
Yes, it is, Your Honor. That Masco proposal contemplated the paving of both the phase 1 and phase 2 roadways. So that 6,020 or 6,040 tons that appears in that Masco proposal, that was the estimate needed to pave both the phase 1 and phase 2 roadways. So half of that was paid and half of it was not.
And do I understand that the total of the 2 roadways in phase 1 and phase 2 did not exceed the 6,020 tons?
The testimony by Casey Daniels was we nailed it pretty close. We got very, very close to that amount. So there might have been some overage, but when he was deposed in the case, he was quite proud of how closely they got to that 6,020 tons.
Again, for just the roadway?
For just the roadways, that's correct. Now, you see that in getting back to the timing of the filing of my client's deeds of trust, that occurred on July 13th of 2007. It was not until August 15th of 2007 that ELL, which was the contractor on this project, was assigned the golf course cart paths by the developer. The next day, ELL went back to Knife River and said, can you please provide to us an estimate of the asphalt needed to do these cart paths? And oh, by the way, we'd also like to use your paver for some of the work. A new estimate was drawn up. The work was performed beginning on August 17th and continuing through August 29th. The outstanding balance on that was approximately $49,000. This was in addition to that $6,020 that appeared on the Masco proposal. The cart paths were only put into phase 1. And the testimony of Casey Daniels, which appears in the record at volume 6 at page 1011, says that as the front 9 was about 80% paved, and the back 9, when I asked him, and the back 9, is any of that paved? 0% is paved. Is any of that cart path prepped for paving? His response, not even close. So approximately 80% of the cart paths on the front 9 were paved, back 9, nothing was even prepped for paving. So for this outstanding work, $166,000 was owed. For these cart paths, approximately $49,000 was owed. The critical thing that I want to draw this court's attention to in the short time that we have for this appeal is the timing between the last date of building on the phase 1 roadways and the first date of building on the cart paths. It was a 113-day time lapse. And that is critical because this court has held on numerous occasions that you cannot add to a completed contract, you cannot tack two contracts together, and you cannot provide trivial work for purposes of the timing for extending the time for filing a claim of lien. A claim of lien under the statute needs to be filed within 90 days. And here, they are sitting on $166,000 of an outstanding balance. My client files its deeds of trust, more time goes by, and they go in and they do $49,000 more work that had not previously been included in the Masco proposal. Recall that the Masco proposal only contemplated the amount of asphalt necessary to do the roadways. Now, the error that the district court made on this is that she read the Masco proposal to be very broad and open-ended. The testimony presented by ELL and Knife River was, we intended it to include all of the asphalt paving, and she agreed with that interpretation. If you're to look at the Masco proposal, it doesn't indicate all of the paving on the project.
So you are arguing that 45508 applies?
I am arguing that 45508 applies. That's an alternate argument that we're making here.
Right.
Yes. Go ahead, Your Honor.
Okay, it starts getting jumbled. So have I got a handle on this? I was looking at it as kind of a 45501 improvement versus 45505 structure, and then 45508 kind of out here on the side is saying you need to identify the different projects. And the district court said no to 508.
That's correct.
But yes to improvements, but no to structures, just to oversimplify. Is that the way you get it?
Something along those lines, Your Honor. The timeline that I'm drawing out here is to point out that it's our belief that two contracts did exist, and they were untimely in filing their lien with respect to the roadways, and they're junior in priority filing their lien with respect to the cart paths as to my client. The alternative argument that's presented in the briefing is the 45508 requirement. And what the district court had done with that 45508 requirement is said that these are not structures, they're simply improvements. And it's not two improvements, it's only one improvement. And our argument in that regard is clearly there's two improvements here. A roadway is not the same thing as a cart path, especially when they're constructed at materially different times using different processes. Was asphalt used in both? Yes, it was, but that does not mean that they are the same thing. Based on this court's decision in Hopkins Northwest, the district court said, well, since these are improvements, not structures, there is no designation requirement. They didn't have to allocate the amounts due on either of those. With all due respect to this court's decision, I think this case presents facts that make that structures versus improvements distinction an unnecessary distinction to make. If you look at the Hopkins case, the Hopkins Northwest case, and the Warren case out of California upon which it was based, there's very good language in there that makes it clear that if things can be apportioned, they probably should be apportioned. In the Warren case, it was moving dirt from one lot to another. Very difficult to apportion. In this case, it was constructing a roadway and submitting an invoice for $166,000, and then 4 months later, constructing cart paths and submitting an invoice for $49,000. I think that's precisely the type of allocation or designation that 45508 contemplates. So regardless of whether these are classified as structures or improvements, it's our position that 45508 should have applied. I'm out of time for now.
Suggesting that we would have to overrule Hopkins in order to do that?
No, Your Honor, I'm not, because the district court erred when she characterized these roads and the golf courses as improvements rather than structures. If this court would reverse that error and say that these were structures subject to the designation of 45508, it would not be necessary to touch Hopkins Northwest at all.
So you would equate these to wagon roads?
I would, yes, Your Honor.
What is a wagon road?
A wagon road, in my view, is a dirt road. It was the only type of road that existed at the time that the statute was written. It's the road upon which vehicles traveled at that time.
Didn't it say railway also?
It also said railway. Yeah.
Which is
But
easier
in
to
addition,
visualize.
we don't get there if we find two contracts.
You don't even get there if you find that there were two contracts that were improperly tacked together, correct, Your Honor?
And I guess I have one other question. Are you arguing that that's a disputed issue of fact, or that this court could rule as a matter of law that there are two contracts?
I believe that this court could rule that as a matter of law on two different grounds. I think the facts just clearly lend themselves to say that there were two contracts, and I think that this court is also in a position to create a bright line rule where if more than 90 days elapses between the cessation of work and the starting of a brand new project, there needs to be some type of inquiry made by the lien claimant. If you look at all of the cases where there's an issue regarding the inquiry made by the lien claimant, the additional materials were provided within the time, prior to the time that the lien would have otherwise expired. Gem State v. Whitty is the only case where the additional materials were provided outside the expiration date of the lien, and the court said, no, that's just too long. Once the lien has expired, you cannot provide additional materials for purposes of extending the time for filing that lien. So I think there's a couple different grounds that this court could rule that as a matter of law.
All right, thank you.
Thank you, Your Honor.
May it please the court, David Crick on behalf of the plaintiff cross-respondent, Hap Taylor and Sons, Inc. Just for my own benefit, I'm going to refer to the company as Knife River. That's an assumed business name. You've probably noticed a number of names within the record here. A company started off with a business name Masco, ended up at Knife River. So that's the party that I represent in this case. I want to start by taking up this issue of the scope of the contract. And this court recently issued a decision about scope of contract, whether work by lien claimants performed on multiple contracts, and that's the Credit Suisse Tufel Nursery decision that was published earlier this year, 156 Idaho 189. And starting by easily distinguishing the facts of this case to the facts of that case. That case involved a claimant that had a series of written contracts, established completion dates, and in fact, the court found each of those annual contracts were paid in full. And what the claimant was doing in that case was trying to tack back to 2004 an unsigned agreement, work that was done each successive year. And the court found, no, your agreement appears to be each of these written agreements standalone, and so we're not going to view this as a series of transactions, but instead standalone agreements. Now, contrasting that with the proposal that was accepted, which is the only written agreement in this case signed by the parties. And it's very clear, Your Honor, to the court, excuse me, that this proposal and agreement contemplates a series of transactions to be paid on a unit price basis. In that regard, I think it is more akin to an open account than it is to a defined fixed sum contract. And
Mr.
now-
Crick, is there
Yes.
anything in the terms of the proposal that would have prohibited ELL from going to somebody else if they had chosen to
Nothing
do
at
the
all.
golf paths?
I apologize, Your Honor.
With
No.
someone else?
No, in that regard, I don't think it's any different than if a builder chooses to order supplies from Franklin Building Supply. They don't have to keep ordering supplies from that particular vendor. And here, they got a number, they got a unit price, and they decided to go ahead and order materials. And I think that's when you look at the terms of the proposal, Justice Trout, they lend itself to an open account because the material terms are there. It says, what type of asphalt do you want? It's classified. It then gives a price, gives a unit price, and then it sets forth the terms of payment. That, in fact,
It also gives an approximate amount, which apparently was used up.
and I would disagree with that. And in fact, the record, Your Honor, shows that only 4,986 tons of asphalt was actually utilized in the road paving. And so we dispute that issue. And that can be found in the record because it was billed on a unit price basis. That's in the record at page 1,153. When you look at that document, you will see Knife River only charged for actual tons of asphalt used for paving. And we do not agree with the characterization that the roadways were completed. And in fact, Mr. Daniels, the president for Extremeline, testified continuously at his deposition, nothing was finished out there. And I apologize if I'm jumping around, but one thing that also lends itself to is this notion of whether Knife River should have been on notice of any activities on the project, are they distinct or not. Mr. Daniels also testified nothing was completed. The cart path work and the roadway work were going on simultaneously. And part of this foreclosure with so many claimants, there were companies working all over the place. And so in that regard, in specific response to your question, we believe the evidence shows the roadways were not completed. And as we've also pointed out, it appears work was actually taking place within the right-of-way with culverts being installed on the very last day of work, which again Mr. Daniels testified to. That was part of what he was doing under his contract as part of the site work of the development that was within the highway district right-of-way. So we also dispute whether the last work was only limited to cart path work, but instead was work within the development. With that in mind, and just to finish my thought on the unit price contract, because I do think it is relevant, that analysis, and again, that was discussed in the Credit Suisse Tufel Nursery case, citing back to Subert Excavators, that the amount was unascertained. The amount of the contract was unascertained. It specifically states billing to be based on actual tonnage. So they don't know the full cost. And maybe a way of also contrasting this is, had Extremeline gone to another company for paving, Knife River would have no right to say, hey, wait, we have a contract for 6,000 tons of asphalt. We get our expectation damages of lost profit. No. The parties' agreement is clear and unambiguous, and they understood it. The testimony given by the president of Extremeline and the project manager for Knife River is clear. We intended this to be for all asphalt paving through the entire development.
Well, I know that was their testimony, but in looking at this document, that's why I asked you the question. I don't see that anywhere. It looks like a one-time agreement for what they approximated as the amount of tonnage they would need, understanding nobody's bound by that. It's an approximate, and it may turn out to be different. But it appears to be a one-time come out and provide, even though it may take days to do the paving, it's a one-time contract, and subsequently, in August of 2007, they had another written document. I realize it's not signed by both parties like the proposal is, but it seems odd to me that if they already had this written agreement that apparently was open-ended and they could continue to provide paving material ad infinitum, that they wouldn't need to go forward and have yet another piece of paper. I understand the price of the asphalt changed during that interim period, and I believe that's the reason they did the small job worksheet. But to just simply look at the proposal, I don't see how that somehow contemplates an ongoing relationship over months and months as opposed to a one-time will provide approximately 6,000 tons of asphalt.
2 points in response to your question, Your Honor. First one is that Mr. Rosen testified in his affidavit that had that call in August of 2007 been intended, or at least as he understood it, a request for a new bid, a new estimate, he would have done a new proposal, because it was important to Knife River to have their standard terms, which are contained in the proposal. And so the small job worksheet actually identifies a couple of other items of work that are slight variations from the proposal that it makes sense, Your Honor, to have identified in a small job worksheet. And that is the thickness of the asphalt went from 3 inches to 2 inches, which is something that it makes sense for Knife River to want to document, because the small job worksheet is intended for the crews. If you look at the bottom of that document, it states, use small job number on dailies. A lot has been made in this case. The daily reports have different job numbers. It's only because of the small job worksheet, internal to Knife River. The other item, to finish my thought, Your Honor, is yes, there was an increase in the cost of oil, which kicked in the escalation clause in the accepted proposal, but also there was the use of the paver. And it makes sense for Knife River to want to document that in its own small job worksheet to ensure that the crews are charging for that. So again, I think it's consistent. In total, all asphalt paving was only 5,680 tons. Again, that can be derived from the actual tonnage that was billed on the project. But in response to your question, I think the key to that is how the parties conducted themselves in August of 2007. Mr. Rosen testified he understood it was being ordered under the proposal, priced it under the proposal, simply provided an estimate of the amount of materials because that's what he was asked for. And Mr. Daniels testified in his deposition, these were brief conversations. Basically, I need more asphalt. It's going to be for cart paths, 2 inches on thickness. Can I use your paver? And Mr. Rosen certainly didn't understand that to mean, oh, well, we've got a new agreement.
Counsel, so what is it that you would like this court to do about that? I understand your position, and it flows as an argument. Was this material before the district court?
Yes, it was.
And you disagree with the way the district court decided?
I do not. In fact, the district court looked extensively, and this can be found in the first motion for reconsideration, because by this time Mr. Daniels' deposition had been taken, and she looked extensively at how he testified. She quotes the specific terms of the proposal, which she relied upon to make her finding that, in fact, all the materials were provided under a single contract. And part of why I think it is akin to an open account is she cites back to an old case, the Valley Lumber Driesel case, to say that all of it, the way the parties were treating it, is that they were all charging it to the same account, a series of continuing transactions. So no, in fact, we believe the court got it right.
Does the fact that you have, the inferences from the change in thickness, seems to me you could draw a different inference, and that is, I've got a 3-inch contract here, and it's X amount of tons for 3 inches, not for 3 inches and any 2 inches stuff you got laying around. It's a separate contract for 3 inches at X tons. So then you get a different proposal, open request, whatever you wish to call it, for 2 inches. Could another inference have been drawn from that evidence?
Well, I don't believe so, Your Honor, because the material's the same. The class of asphalt, the mix design was the same. It's merely because it's being charged by the ton, it's just how much goes down. And so, no, I don't think it does change the analysis. And a final thought on that small job worksheet, I think it's also indicative of the party's intent, what they understood their agreement to mean, where Mr. Rosen wrote bill proposal and testified in his affidavit. That meant bill the accepted signed proposal. Again, the business practice of we want to make sure we have our terms to whatever it is we're going to go do on this project.
But you do that if you entered it into a separate contract, too.
But he would have gotten the proposal signed by the other party. The small job worksheet, Mr. Daniels testified, never saw it before. It was something internal to Knife River, which again I think makes sense. It's consistent that they're going to want to have that covered so they know what their crews are going to go do.
Okay, I'm sorry to interrupt.
Why do you think that they put in a start date of 8/17/07 and a completion date of 8/30/07, and then in the job completion date, it says 8/17 to 8/29. I mean, why would you put in a start date if it was not a new agreement?
I believe, Your Honor, it was simply for scheduling purposes, because in the record there's also another small job worksheet, and that was for an asphalt repair. And that one, I think the reason for the small job worksheet was to identify for the crew what they were going to go do, and this was no longer production paving. Now I'm referring to the July small job worksheet where they charge by time and materials. So again, the work's being done under the proposal, and I think under the theory of the Franklin Building Supply case, repairing that asphalt, since it's within the scope, is potentially lienable work. So in response to your question, I think it was simply for scheduling purposes because, again, the project manager and estimator for Knife River was very clear in saying, if I was being asked for a new contract and a new bid, I would have done a new proposal and wanted it signed. In my precious time left, I do want to address this 45508 argument. And I should have cited to this in the brief, but there was a decision fall of 2013, the Intermountain Real Properties versus Draw case. And in that case, there was an issue of paving by a claimant. And the court describes that work as grading, filling, and surfacing in reliance on the Hopkins decision to find that paving is in fact an improvement to land. Now, I understand that claimant had issues with whether the owner ordered the work, but I think it's a further indication of a plain application of the statute that in fact asphalt paving is an improvement to land, not a separate identifiable structure. What I would further ask the court to look at in this appeal is what's being asked by IFA as a lender. It is asking for a narrow, restrictive application of these statutes to find that the lien is either invalid or subordinate to its interests. And that is not the goal of the lien statutes. And in fact, I think not only a plain reading of 45508, but also the court, and in this instance the district court's application of 45501 relative to 45505 is appropriate. And that has to do with the amount of land subject to the lien. And in that regard, I think this work falls within the Court of Appeals analysis in the Fairfax versus Ramirez decision. And that in fact these golf course lots directly benefit from the work that Knife River did. It's the only access, in fact, in some of the demonstrations you've seen and in the plat itself that's part of the record, it's clear that that work benefits the golf course lots. So with that said, I certainly stand for any further questions.
What do you view a wagon road to mean in 45501?
I do not know, but I don't believe any wagons have run on the roads that were constructed by Knife River, and I don't think that was the intent.
Well, I guess what I'm puzzling over in looking at 45508 is trying to figure out what surfacing means. Does that mean something other than just simply bringing a road grader out or moving dirt around? And it seems to me that in 45501 it's contemplating, because it follows wagon road and the other list, was saying, or any other structure. So it seems to me that the statute is talking about adding something to the dirt that constitutes a structure, and it uses wagon road as an example, it uses railroad as another example, which would seem to me to mean if you go out and do something to the property, paving it, putting a building on it, putting a roadway on it, that constitutes a structure and is not just simply leveling, grading, and moving dirt around.
Well, Your Honor, unfortunately, I can't tell you what I believe a wagon road is. I have not formed an opinion on that. But I think the court undertakes painstaking analysis in the Hopkins decision of the evolution of 45501, and I believe it was 1951 to create this lien against the land. And that is, so some of the language may have stayed in there. Maybe wagon roads, and I'm not being facetious, were still being used in 1951. Maybe there was relevance to leave it in. But I do think the changes make clear that this type of work, because keep in mind what creating this road was. It's stripping the overburden on the surface, excavating out dirt, putting in road-based material, finishing it. You have to compact it, grade it, and then putting asphalt on it, which is a mix of aggregate, oil, compacted, leveled, and surfaced.
So you've added something.
Which part?
By this whole process, you have added a thing to the ground. You didn't just excavate it and move the dirt around.
I think it's been permanently changed, Your Honor. I think what's now happened is that property is now directly benefited, not from some structure, because again, the body of case law on this goes to, is the land a mere incident to the building or structure? And then we look to 4505 to say, is there any land that benefits from it? Well, in this instance, no. I think the ground's been changed. The property's been changed. So that's my response to your question.
Thank you.
Thank you.
Thank you.
How much time? 3 minutes, Your Honor. Very well.
Thank you, Your Honor. Given the short amount of time that I have, I want to focus this court's attention onto a comment made by counsel when he said, when that call came in August, we wanted to make sure it was billed to the proposal. Had that call not come in August, Knife River would have no lien rights with respect to the roadway. When that call came in August, their lien rights were long since passed. It was that call that came in August that said, hey, we want something more and different, that enabled them to revive lien rights that would have otherwise been expired. If the call hadn't have come, and Justice Trout, you pointed on this, they could have called somebody else. Had that call not have come, they would have had no lien rights for the roadway work. So why did they bill it to the proposal? It's the best way to revive those lien rights. And really, that's the economics behind what was going on here. And there's a lot of different ways to look at that contract and what was going on with the contract being a contract for an open account and whatnot. But the net bottom line is, had that call not come, they would have had no lien rights with respect to the roadways. This court has had a number of decisions with respect to contracts on an open account. And counsel suggested that this case was quite similar to what was going on in Franklin Building Supply. But critically, in Franklin Building Supply, the court made a very important distinction between strict materialmen and people who are on site also performing labor that know the status of the project inherent in the performance of the project. Knife River knew exactly how much of those roadways were completed because it did the work. Knife River knew that the roadways had been substantially completed. Now, Knife River argues in its briefing, hey, we went out and did some tie-ins later that were related to the roadways. Critically, they didn't invoice for them. So when they say, well, this was an open price unit-based contract, but that extra roadway work that we did that we want the court to look at, we didn't bill for it, undermines that argument. Was it a unit-based contract or was it a roadways contract? Depending on the direction they want this court to fall, they argue it differently. But the critical thing is, had that call not come in August, they would not have lien rights for the roadways. And if you look at Jim State v. Whitty, because those additional materials were provided after the time for filing, the lien had already expired. I would submit to this court that as a matter of law, they cannot rely on that to revive lien rights that would have otherwise been expired. The other cases of Valley Lumber versus Driesel, Jim State School District versus School District number 8 in Caribou County, Franklin Building Supply versus Sumter, all of those involve the provision of additional materials before the expiration of the lien rights. One of them came down to 59 out of 60 days, but it was still before they had expired. I'll stand for any questions that your honors have as I am out of time.
None. Thank you very much.
Thank you very
much. Thank you to counsel. It's a tough case. It's now under advisement. We'll render decision.
Thanks very much. Very concise argument for me today.
Thank you so much. Very much.
Good argument. Yeah. I didn't say anything that I really didn't mean, that's for sure.